court is going to call 2020 CR 4098A, State of Texas versus Brianna Renee Mitchell. Can I have parties announced for the record for the state?
Brittany Sparks.
Defense?
The attorney record, Monica Guerrero. I'm covering for Ms. Guerrero. Joseph Stateson. Ms. Mitchell, would you give this judge permission for me to do the plea in case of Monica Guerrero?
That's right.
All right, I'm going to need you to speak up, okay?
Yes.
All right, are you Brianna Mitchell?
Yes, ma'am.
All right, I'm showing you what's entitled Motion to Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes.
Are you the same Brianna Renee Mitchell who was placed on community supervision in 2020 CR 4098A for the offense of manslaughter on December 10th, 2021 for a term of 10 years? Is that you?
Yes.
All right, state.
Yes, Judge. Violated condition number 1 on or about the 8th day of September 2022 in Bexar County, Texas. The defendant, Brianna Renee Mitchell, committed the offense of possession of controlled substance, penalty group 1, in violation of condition number 1.
How do you plead to that? True or not true?
True. Violated condition number 1 on or about the 8th day of September 2022 in Bexar County, Texas. The defendant, Brianna Renee Mitchell, committed the offense of fail to ID fugitive intent to give false information in violation of condition number 1.
How do you plead to that? True or not true?
True. Violated condition number 1 on or about the 8th day of September 2022 in Bexar County, Texas. The defendant, Brianna Renee Mitchell, committed the offense of evade arrest or detention in violation of condition number 1.
How do you plead to that? True or not true?
True. We'll waive the other violations.
Any objections to the state's waivers?
None.
All right, did you understand by pleading true to violations 1, 1, and 1, the court could find it true, grant the motion, and sentence you up to 10 years in prison and up to a $1,500 fine? Did you understand?
Yes, ma'am.
Knowing that, do you still wish to plead true to violations 1, 1, and 1?
Yes.
The court will find 1, 1, and 1 true. Is there an agreement?
Yes, Judge, we're asking that you grant the motion, revoke her probation, and sentence her to 10 years in TDC. In addition, Judge, will be taking into consideration cause numbers 2022 CR 10345B, County Court cause number 692652, County Court cause number 692653.
Is that the agreement, defense?
It is, Your Honor, and I believe I may have made a clerical typo on the certificate of appeal. I may have put the case being TIC instead of the NPR with minus.
Yes. No, I'll correct that. Is there any objections to the court correcting that with the proper cause number?
None from the defense. And if I may put something else in the record, Your Honor.
Yes.
This offense was created during a time where Ms. Mitchell was on federal release, supervised release. She has federal back time, and post the offense, she did time in federal prison. I have some dates if I could put those on the record.
Yes.
She was in custody in federal prison or federal custody on April 18th, 2016, where she was sentenced November 17th, 2016. And she was not released until April 3rd, 2020. When she was released April 3rd, 2020, it was supervised release. And there was a revocation hearing. And she has federal custody time from February 18th, 2022 to April 13th, 2022. And we ask that she be given credit for federal time in addition to the Bexar County time.
So you're asking for credit from April 18, 2016 to April 13, 2020?
We are, and I did explain to my client that is prior to the offense date, but she was still in custody post that also, and that it's the court's discretion to award time.
So with regards to the dates from April 18, 2016 to April 13, 2020, was this case open on a motion to revoke or no?
I don't believe it was on a motion to revoke.
All right, was this case pending?
I have to,
Right.
I can check one moment, Your Honor.
Okay, so that's what I want to know about that. But with regards to the February 18th to 2020, February 18th, 2022 to April 13th, 2022, this was pending, correct?
Yes.
All right, so she will definitely receive credit for those dates. I just need to check on the April 18th date. Well, it appears, Ms. Sparks,
Yes, Judge.
on this case, I'm being informed by the clerk that this case was actually on the system January 2nd, 2016.
Yes, Judge, that's what our computer shows.
Okay, so we can go back on the record printer. So are you asking the court to follow this agreement?
Yes.
Are you waiving your right to appeal?
Yes, ma'am.
All right, then the court is finding 1 and 1 true. The court will follow your agreement, revoke, sentence you to 10 years in the prison, take in consideration 2022 CR 10345B, County Court Cause number 692-652, 692-653. Give you credit for any time.
Right away, the stakes are crystal clear. Brianna Mitchell already had a manslaughter conviction hanging over her, and probation was essentially her second chance. But when someone violates probation after a serious felony like that, judges often treat it as the court's patience running out. The big question now is the judge about to give her the full 10 years.
Served, and the court will give you the credit served in federal custody from April 18, 2016 to April 3rd, 2020, and February 18th, 2022 to April 13th, 2022. Is there anything else from either side with regards to sentencing?
No, Judge.
Nothing from defense.
All right. For some reason, there's no affirmative finding on this of a
On the
deadly weapon.
original?
Yes. Let me see something, just one moment. I don't know what the underlying facts of this case were. Just give me 1 second. I'm assuming a weapon was involved, be it a vehicle or something else. All right, yeah, it's involved a gun.
It appears that my client appears that it was with the co-defendant who had a gun. Her client didn't have a gun, but that was not negotiated with the district attorney's office with Marcus prior to this.
All right, because I mean, according to the, and I know this is before your time, Mr. Statesman, but according to the indictment, it says that Brianna Mitchell did recklessly cause the death of an individual, namely, the complainant, by discharging a deadly weapon. So this is pre this attorney, Ms. Mitchell, but that's what's in the paperwork. So there's going to be an affirmative finding. So there's an affirmative finding of a deadly weapon. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck. We can go off the record. I saw in this case where parenting classes were ordered for you. So here's the thing. Someone else is taking care of your children or your child. When you are released from prison, and at some point you will be, do not go up to the house acting as though, here I am, let me put my rules in place and disregard whatever rules have been set for your children. You understand? You're going to have to humble yourself. All right, good luck to you.
Thank you, Judge.
Thank
Just
you.
checking in on Charles Jones. I got your email.
Who's here on Jared Johnson?
Did anything happen?
Ross Jr.?
Okay.
Yes, Judge.
Could I have the parties announced for the record, for the state,
Jason Garahan,
for the defense?
Orlando Castellon.
And are you Mr. James Ross Jr.? All right, you're going to need to speak up.
Yes, ma'am.
All right, did you review the application for community supervision with your attorney? Did you understand it and sign it? And did you review the true bill of indictment with your attorney? Did you understand it?
Yes, I did.
Counsel, do you waive the reading of the indictment?
I do, Judge.
State, are you proceeding on the indictment as presented?
Right away, the judge is setting a tone you don't usually see in a felony drug case. Most hearings start stiff and procedural, but here the judge is already curious about Ross's acting background that may sound casual, but in courtrooms moments like this can actually reveal a lot about a defendant's credibility. Is this a genuine story or the opening act of a performance?
No, Your Honor, we'll waive count one, proceeding on the repeater, and count two, taking it at first.
Any objection?
No, Judge.
All right, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, I did.
Did you understand you're charged with possession of a controlled substance, penalty group 1, 4 to 200 grams? Normally, the range of punishment for that is 2 to 20 years in prison and up to $10,000 fine. If the state proves the repeat offender enhancement allegation beyond a reasonable doubt to the court, then your range of punishment will be anywhere from 5 to 99 years or life in prison and up to $10,000 fine. Do you understand?
Yes.
All right, if you have a plea, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes. No.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Sir.
And did you intend to give up those rights and enter into a plea in this case?
I did.
Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Judge.
Mr. Ross, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
I am.
Are you a U.S. citizen?
I am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, the state is proceeding on count 2. You are to agree that you've been previously convicted of 1 or more felonies for purposes of enhancement. Punishment is to be assessed at 8 years in the prison. There's a $2,000 fine. State recommends community supervision, and there's to be restitution to the SAPD for lab testing. Did you understand that to be the plea?
I'm a little bit cloudy, Your Honor.
Okay, uncloud your mind.
I think he heard that it was to be sentenced at 8 years in prison, but I think he did not hear the part where it was recommended for probation and that he was applying for probation.
All right, I'll repeat. Your plea bargain agreement, the state and the defense and yourself have agreed to proceed on count 2 only. Do you understand?
I do.
You are to agree that you've been previously convicted of 1 or more felonies for purposes of enhancement. That's that repeater count that's in the indictment. Do you understand?
Yes.
There's a $2,000 fine. Do you understand?
Yes.
There's a recommendation for community supervision. Do you understand?
Yes.
There's to be restitution to the San Antonio Police Department for laboratory testing of the drugs. Do you understand?
Yes.
If you are revoked, you're looking at 8 years in the prison. Do you understand?
Yes.
Do you understand that to be your plea?
Yes.
Defense is at the plea.
It is, Judge.
State is at the plea.
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
I did.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court.
This moment might seem routine, but it's actually crucial. The judge is confirming that Mitchell understands the motion to revoke community supervision, which is legal language for ending probation, and sending someone to prison if she admits the violations. The judge can immediately impose the original sentence that was hanging over her head.
Do you understand?
Yes.
Counsel, are there been any such motions?
We have no rulings, Judge.
Outside the agreement, the state is requesting that your community supervision be for a term of 8 years. There be a TAP evaluation and 200 hours of community service restitution. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
I do, Your Honor.
Then to count 2, how do you plead? Guilty, not guilty, or no contest?
No contest.
To the repeater enhancement paragraph, how do you plead? True or not true?
True, Your Honor.
State any evidence.
State officer, state exhibit number 1 with office attached.
No objections, Judge.
All right, state, you may be excused.
Thank you.
Did you review the waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. The court will find the enhancement true based upon your plea of true and based upon states exhibits 1 and attachments. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
No, Judge, I just asked that you follow the plea agreement.
All right, are you employed?
Not yet, Your Honor.
When's the last time you had employment?
Right before I was arrested on the 13th.
Doing what?
Modeling, acting,
I'm sorry, what?
modeling, acting.
I understood also that he was participating in research studies as well. Is that right?
All right, you say modeling and acting. Where might I have seen you? And in what might I have seen you?
In catalog modeling.
All right, what catalogs?
JCPenney's.
JCPenney still has a catalog? What year would that have been?
23, 22.
All right, I'm gonna look that up. What were you modeling in 23 in the catalog?
Here in San Antonio.
I had a client, Judge, who actually was a model as well. He was modeling, I think, JCPenney's Hager pants and such.
Was his name James Ross
It was
Jr.?
not, but
So you say modeling and then you say acting?
Well, acting hadn't taken off yet. I just started the classes.
Oh, so you were in classes for acting? Because I will tell you, I watch a lot, so
They were.
I would have seen you if you say, name what you were in.
I was auditioning for it.
For what?
New Tyler Perry movie,
And what is that?
Stranger Things. And also Scream 7. I got the emails if you want to see them.
Oh, yeah, I would love to see the emails for this. Michelle, maybe we could be in a Tyler Perry movie.
Here.
I knew there was something about him because his name is actually the name of J.R. Ewing's son in Dallas, James Ross Jr., J.R. Ewing.
never watched the show.
Oh, my gosh.
I was up on that.
Maybe.
And you're
Now the formal court process begins, and here's the big legal issue. Ross is charged with possession of a controlled substance between 4 and 200 grams, a serious felony normally that could mean 2 to 20 years in prison. But there's a twist, prosecutors are also alleging he's a repeat offender, which can dramatically increase the potential punishment.
Texas? Okay.
I watched Knight Rider.
Knight Rider, but not Stingray. Well, the Knight Rider you watched, was it the new version?
Oh, no.
Or the old one?
With the Ha.
Oh, who used to be in Young and the Restless as Snapper Foster. But okay, enough about that. And he was also the second Snapper Foster, not the original one.
I was more of a General Hospital person myself, Judge. So
Oh, wow. The Quartermains?
I don't remember because I was watched it with my aunt. So
Okay. He's like, what are they talking about?
Uh-oh.
All right, so here's my question for you. In the past, what have you used drug-wise?
Marijuana, codeine, promethazine. Marijuana, codeine, promethazine,
Okay.
Xanax.
That will mess up your face if you want to be an actor.
No,
You know,
I'm done with the drugs all the way.
all right, they say acting is for the young. And do you have any children? 8. When's the last time you saw your 2-year-old? All right. This is what the court is going to do. Court is going to sentence you to 8 years in the prison, suspended and probated for 9 years, $2,000 fine that will be probated, restitution to SAPD for laboratory testing, There's to be 200 hours of community service restitution. 100 hours will be deducted. For parenting classes, I'm gonna order parenting classes. And I tell you what, this is some incentive to improve acting skills. You may be acting right now, which is great acting. If you provide proof that you were actually in the JCPenney catalog in 2023, not 22, but 2023, I'll deduct 10 hours of community service restitution, and I'll deduct the remaining 90 if you actually are in the Tyler Perry series or someone series. Not as an extra, because those are just people in the background. You understand? If you have speaking lines, I'll waive the remaining of the hours, and that will give you incentive to work on your acting skills. All right, there's to be regular reporting by Zoom or in person, regular random UAs, field visits, one time per month for 6 months. Ms. Abrams, how long will it take for a TAP evaluation in custody and out of custody?
Judge, in custody, I need a out of custody longer.
When we say longer, what are we thinking for out of custody?
A month.
All right. Here's the thing. You're going to be tested on a regular basis. I can keep you in jail for the 2 weeks for the TAP evaluation, or I can let the TAP evaluation be out of custody.
I know he wants to be out of custody, Judge, and that's.
Here's something important: the state decides to proceed only on count 2. That's a common prosecutorial move during plea deals. Instead of risking trial on multiple counts, both sides narrow the case down to one charge. It streamlines the process and often leads to a negotiated sentence, something that's about to happen here.
Part of the reason we were here is to address that, but we were able to resolve this case, and so I believe that he's motivated to be released, and so if there's other conditions.
Here's the thing, your attorney is not going to be the one on probation, it's you. So we can do the TAP evaluation in custody or out of custody, but I'm telling you, if you end up testing positive for drugs while you're out of custody, they're going to bring to me a motion to revoke or tell me what's happening with you. Then you and I are going to have another conversation, and that conversation may or may not result in you doing a TAP evaluation in custody.
Out of custody,
All right, TAP evaluation out of custody, follow recommendations. There's to be 90 sober meetings in 90 days, proof of employment within 30 days, no employment as a home health care provider or with minors. And there's to be no contact with Mark Daniel Lewis. Probation, is there anything else he needs? Is there anything else you need from the court in order to be successful?
just understand you said 90,
Sober meetings in 90 days. So every day you need to do a sober meeting for 90 days. Those are your AA meetings or NA meetings. You can either do AA meetings or NA meetings, but they're called sober support meetings now. If you go online, you can find one that is near you.
and to get a job too.
Yes. Anything else?
Yeah. It is.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it? Did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. I know I sentenced you to 9 months probation. I'm sorry, 9 years probation. You're like, yay, 9 months. If you complete everything early, you can always come back. and ask for early termination. You understand? All right, and this court, to be successful, you need to stay in communication with your probation officer. If you have an issue, let them know. If you feel they're not addressing it, you can always come back to court and speak to me. You understand? All right, good luck to you. They'll go over your conditions with you. Thank you.
Thank you.
Listen closely to that number 5 to 99 years or life. That's the power of a repeat offender enhancement, even though the underlying charge might normally top out at 20 years. Prior convictions can turn a mid-level felony into something that carries life. Imprisonment suddenly, that plea deal Ross is considering looks very different.